Come on in, folks. Get fired up. We're about to talk about some exciting stuff. First of all, thank you for being here, and thank you for the opportunity to speak with you, because one of the things that's really cool about what we're going to talk about, we're not going to get into a bunch of legalese stuff. I promised that in the write-up that I sent into RVAsec. But what we are going to do is talk about some things that will ultimately put you in a better position to get a better outcome in what is not a fun situation dealing with a breach or a data security incident. There's a real kind of interplay between, an important interplay between the technology side of things and the legal side of things when we're dealing with data security. I think the technology part of it is something that's right there in front of us. It's pretty obvious. That's the thing we think of, we see, we're dealing with. We have an incident we need to manage. You know, we're digging right into from a technological standpoint. Hey, what happened? What's the problem? How do we fix it? What data was impacted? All of the things from a technological standpoint that kind of jump out at us and we probably more readily think about. But there are legal issues that are very important to think about. And considering some of the legal things that we're going to talk about, those are the kinds of things that will put you in a better position. I say you. I'm saying this from the perspective of, it may be that it's your employer that you work for. It may be that you provide services in this arena for clients. I'm just probably going to talk about it generally as clients, because if it's your employer, it is kind of your client. You're trying to help them succeed. But there are things that we can do and consider from a legal standpoint that will put us in a better position to have a better outcome, minimize the harm that's going to otherwise that could flow from a data security incident. So that's really what we're going to do. That's what I get excited about. It's going to be. I'm going to try to keep it interesting for you so that you don't. That you perhaps, if you haven't had a great experience with lawyers, you walk away from this going, man, all right, lawyers are okay. This guy, he can talk it without putting me to sleep. Let me start by just giving you the roadmap. People like to see where we're headed. This is where we're going. I'm going to give you a little bit about me, not a big deal, just so you can kind of understand my perspective on things, because that's important as you're taking what I suggest for you to consider, and then kind of filter it to make it work for you, for your organization. Talk about the goals of what we're going to do today, but then hit some kind of high-level concepts, and then we'll really dig into the breach experience. Some of you may have had I'll say either good fortune or misfortune to be a part of a data breach situation or a security incident. Maybe it didn't turn into a full-blown breach, but you've probably found yourself dealing with it. We're going to go through that and talk about some important elements of that, not only talking about the legal side of it and things to keep in mind, both prior to and when you're in the middle of a breach, legal things that can help get a better outcome, but also some practical things. It's just things I've experienced over time in doing this stuff over the years that I hope will be helpful to you. And then we'll wrap it up and have time for Q&A. I just have Q&A listed here. You're not going to bother me. I encourage you to, hit me with a question if you have something so it doesn't slip your mind, and we'll dig into it. So quickly, just as I mentioned, just so you can understand my perspective, where I'm kind of coming from, I've been in-house as general counsel in the technology world. Some of you, certainly if you're closer to my age range, you'll remember Network Solutions. They're still around, but back in the day, when I first joined them, Network Solutions they were just coming out of the government-sanctioned monopoly of being the only place on planet Earth where you could get a .com domain name. So if you wanted BobbyTurnage.com, it didn't matter if you were in Africa, China, wherever you were, you had to ultimately remotely get to Herndon, Virginia at Network Solutions. So it was really cool to be a part of that company as it grew and morphed into more of a competitive environment. And then I worked with VeriSign as well, because at one point VeriSign owned Network Solutions. And probably, I guess it was the last 8 years I was with Network Solutions, I was general counsel for them. So I have that experience from being inside a business and a technology company and kind of seeing the reality of what happens in a business and dealing with data security incidents. I think that's an important perspective that I hope helps me do a better job in talking with you about things and talking with my clients. And then I also have a good number of years and currently am in the law firm arena. I've been with Sands Anderson now for running on 6.5 years, and I lead their cybersecurity and technology practice. So we call it that. It's about data security, data privacy, and technology. It's got a fancy name, cybersecurity and technology, just to get people interested in it. So everything I'm telling you will be coming from that perspective. Most of what I will share with you, probably everything I'll share with you, as far as practical tips and things that I've seen, they really are just war stories from things that have happened, and I can see that things that we can do that can make a difference. So the goals of what we want to cover, and this was in some of the materials that we submitted for this particular presentation, but just so you know, this is really what I'd love to see us accomplish, just having a real, a better sense for what it's like to be in a data breach situation. You may never have been in one, you may have been in one. I hope that if you are working for a company, you haven't been in a lot of them. I always say, when clients call with a data breach, typically, and it's probably a good thing, that they are unsure of what to do. What's this going to be like? It's chaos, and we're not used to this. I would say that if I had a client call and say, we're used to this, we do it all the time, I'd say we've got bigger issues we need to be talking about if you're constantly dealing with data breaches. So we'll talk about that, a sense for what it's like to be in a data breach situation. Talk about, we want to increase our awareness of the risks to the organization. Some things I think are obvious. Other things might not be as obvious, and I think it's helpful to really get our arms around what is the risk to the organization. Again, I say our client. It could be your employer, your client for whom you are providing services. I think that helps us do a better job as we look at the things we can do to help protect the organization if we're thinking back about what are the risks related to a data security incident. We want to gain awareness of the multiple people and work streams involved, because if you've been through it, you know this, but there's not just one thing to do. There are a bunch of things to do, and they all kind of have to happen somewhat simultaneously. There may be a little bit of a path, sequential operation of things, but there's a lot of stuff happening at one time. So let's kind of run through that. All of this is it's really so that when you leave here today, whether you've been through it or it's not something you've been through yet, you at least have some familiarity, some more familiarity with the concepts that are important. And I think it's kind of like muscle memory. It's going to help you when you are in the trenches in that somewhat chaotic situation, and again, help you get a better outcome. We're going to look at the big picture of a breach, what that's all about, so we can see the moving parts, and then we'll talk about practical takeaways. So we're going to talk about some things from a legal standpoint you can do. The way I would think about it is this. There are legal obligations. You need to comply with those legal obligations. There are legal obligations for data security prior to having a problem, and there are legal obligations when you are in a breach. So we want to make sure our organizations are complying with legal obligations. That seems pretty straightforward. That's an important concept, though. Then there are things that are of a legal nature, but they're not requirements, but they're of a legal nature, and they're things that you should be considering and perhaps doing to help minimize the impact of a data security incident. So we'll talk about some of those as well, and then there are just practical things that we'll talk about. They're not really legal, they're not an obligation, they're not legal concepts, they're just things that I have seen that can make a difference. So important initial concepts to talk about. I think it's pretty, normally when I talk to people about a data breach, they're thinking about the things we read about in the newspaper, and it's almost always about your credit card data, or it's the member information in a healthcare plan, the things that make the big splash in the news. All of that data is critical, it's very important, and it certainly creates issues that need to be dealt with in a data breach. But I also want to help us expand, to the extent it's helpful to you, expand our thinking around what is the data that's at risk when we're talking about a data breach. Employee data you'll see listed there, that's one that often gets overlooked. You're thinking about your end users, your patients, your customers, whoever that is an end user in your world, but perhaps not about the employees, and that's important data we need to keep our eyes on and think through when we deal with a data breach. Also, you'll see there intellectual property and confidential information. And I'm highlighting for you that it's not only yours, that's important, and that might get overlooked. It's stuff about your business. It's important stuff that you don't want other people, and I say business, you could be an organization, a nonprofit, this is just as important for you, on what your, kind of what your strategy is, what your plans are, anything related to your operations that you want to keep confidential, that's at risk when we have a data breach. So we have to remember that as well. Third parties, that might be the most important sub-bullet on the page, because that is an area of exposure for us, for our organizations, that we might not think about, but it's information, say, a business partner has entrusted to you. Think about the contracts into which you enter as an organization, and you're sharing information with other entities. You're giving them confidential information, they're giving it to you. That is going to create exposure for you in the event of unauthorized access or acquisition of information. So that, to me, is a helpful thing to think about as we kind of get our arms around, wow, there's a lot of data that's at risk. It's not just this stuff we normally hear about, which is a huge chunk, but these other things are also critically important. So some primary considerations I just wanted you to think about, and we've kind of talked about it, but there are things you need to do in a breach situation. There's just stuff you need to do. It might be it's just around technology. It's, I have to protect my organization. I have to stop the bleeding. I have to fix things. And there are things that you are required to do under the law. So that's kind of another bucket to think about. And then there are things that are things you should do or could do. You just consider those and see what makes sense for you. So those are kind of level setting, helping us kind of set the table for what we're going to talk about. Here's an interesting one, is that obligations exist both with respect to securing data. So there are certain legal regimes that will apply, I'll say legal schemes that will apply to your organization that talk about what your obligations are in protecting data. And that can be different for different organizations, different industries. Then there are legal obligations that apply in the event you have a data breach, okay? So just remember those two things, because they both are important in helping us get a better outcome. If you're complying with your legal obligations on the proactive side and you follow your legal obligations when there's an incident, then when we get to the end result, it's going to be a much better outcome. We help reduce the impact of the fallout from having an incident. The obligations for us flow from different sources. It really depends upon the type of industry you're in, the type of company you are, what role you play in that industry. And you'll see that, I'm kind of getting ahead of myself there, but you'll see that from a legal standpoint, there are different layers, and I kind of think of them as almost horizontal and longitudinal, I guess I'd say. You have state laws that may apply to your situation. Then you have federal laws that might overlay on top of that you have to consider. It may not affect your organization, but it might, depending on what you do and the type of data you have. So remember, they have states, and you have federal, and you may have international rules that apply depending upon your situation. That last bullet point is to remind you, because I want to keep coming back to it, it's not just about the statutory and regulatory schemes that are out there that are important, but you also have these contractual obligations. Those I think of as a legal obligation. It's not a statute where Attorney General's coming after you, but these are legal obligations that have compliance obligations, I would say, under the contract. Typically it'll say, you have to notify me if there's an incident. Here's how we describe what an incident is. Here's who's responsible for what. So we need to be looking at our contracts as well. Okay? None of this is for memorization. It's to be familiar with you, for you when the time comes, and you will be able to, I don't know if you can see, yeah, you can see that on there, can't you? All right, my people back home are talking to me. All right, so let's keep rocking here. I've mentioned this to you, but to hit the point, the particular legal scheme that's going to apply to you is going to depend upon a number of things: the industry you're in, the type of data you have, the type of entity you are. It's also important to understand that sometimes you may have multiple. So we talked about how you have state, federal, potentially international. You may even have local, like in New York City. There might be something that applies to you. But sometimes complying with one, it gives you an out for the others. But in some cases, you're going to have to comply with more than one. So an example I give you on the screen here is a healthcare company in North Carolina. A number, I would say most probably, states have an exception when they give you the rules for their jurisdiction on what you need to do in the event of a data breach. They usually have an exception. Some do, I'd say most, that carve out certain types of things you'd recognize, like the financial services industry under Gramm-Leach-Bliley Act. But healthcare is another one. It'll say if you are a covered entity or a business associate and you're complying with your obligations in the healthcare world, because there is a regime, regulatory scheme for that around data, then they say, that's good. You're in compliance with our statute here in Virginia if you're doing that at the federal level. North Carolina is an interesting example where that's not the case. They don't give you an exception if you're a healthcare provider or business associate in the healthcare world. So you actually have legal obligations on the federal side, and you have them in North Carolina if North Carolina is relevant to you. One thing I should mention, I don't know if it's a bullet point we'll hit later, but just while it's on my mind, realize that the analysis that has to be done to understand your obligations from a legal standpoint has a lot to do with, in addition to the other things we've talked about, it has a lot to do with where the impacted data subjects are. Okay, it's not an easy yes or no answer on all of the various locations, but what I can tell you is that impacts things. You could be a small company in Virginia, be a small company in the middle of Oklahoma, whatever, but you are operating a business where you interact with and collect data from and sell products and services to customers all over the United States. It is very possible that if you have a data breach and all of your customers are impacted, you have to do the analysis in each state. But it is very possible that if it constitutes a breach in each of those states, you could have notification obligations in each of those states, even though you might just be a small operation in one location in one state. So I've run across some confusion on that over the years. People think because they're just in Virginia, for example, they don't need to worry about the laws in the other states. Definitely not the case. We need to look across the, I'm going to say, user base, customer base, the impacted data subject base, and then that helps us understand what our legal obligations are. Okay. This is where we start talking about the potential harms. This isn't just to scare us into paying more attention. That's important and that's helpful if it can help us, be a little more concerned about maybe the potential harm to the organization. But where I think it is helpful is when we're looking at what are the particular types of harms. That's helpful as we look at what are the things we can do to address some of those harms. There may be some things we can do that address a lot of it. There may be specific things we can do to address a particular component in these potential harms. So we don't need to run through each one. I would love for you to look at them and just be familiar with them. I do want to call out a couple of them, and then it's this slide and the next slide dealing with potential harms. Some are obvious, like that customer, client, patient data. That's the one I started with saying we always read about that in the news, loss of reputation. People talk about that stuff. But I've got the confidential information highlighted there for you, yours and third parties. That tends to get overlooked. That's going to be a big deal if we have an incident. We have to remember that's there. There's exposure there. We need to address it. Some of these costs will also strike you as, they make sense. Yeah, lawyers are expensive. Forensic investigations expensive. But loss of business due to interruption. That's something that, depending on your role in the organization or if you're just helping provide information for people to think through things on the loss side, when you are out of operation, for whatever reason, it's a ransomware attack, whatever the problem is, your systems have been destroyed, you have to get all that back up and running. There's a real loss, there's a real harm to the business or organization in not being able to operate potentially. So, continuing on this list of harms, I've got the contractual liability claims damages highlighted there because I keep coming back to that. Just in my experience, that's one that's not thought of and very important for us. The cost of a customer call center. This is one I've seen catch some clients by surprise because if you imagine, you may have a ton of end users, customers, whatever we want to call them, patients, clients, individuals, but you are not set up to handle an influx of calls and inquiries from all these people basically at the same time. So it can be a real drain on the organization. So there are, no surprise, there are vendors out there that will provide this service for you. And they run on a script, and they'll handle all the influx of phone calls, and they know what they're doing, they're good at it, and they work with scripts that we'll talk about that you can come up with for communication to the outside world. But that's a cost that sometimes is not considered in advance. Crisis management PR firm, I've seen that one come up too, where it's very expensive and people weren't really thinking through that. You may have someone who handles PR, but depending on the nature of your organization, the nature of the breach, it may be helpful to have an outside crisis management firm kind of assist, guide you through the challenges as we're dealing with a breach. I don't want to go too quickly. I want you to be able to digest it, not memorize it, but just digest it and be familiar with it. So now let's dive into, we can see kind of the vast amount of data that's at issue. We can also see the potential harms to the organization. We can understand there are technical things we're going to do. There's legal stuff we have to do. There's legal stuff we should do, could do, and then there's practical stuff. Let's dig into the actual breach experience. Now, there's a lot we can say about a breach. I've tried to give you the things that strike me as the most important for us to be thinking about. And we start by looking at these high-level considerations. Let me eyeball my clock. I'm between this group and lunch, so we're going to make sure we do this right. So these are high-level considerations, just things I want you to keep in mind when you're thinking about what do we do, what happens in a breach, what's this going to be like? There are many moving parts. We talked about that. Parallel paths. Let me give you an example. So one of the first things we're going to do, of course, if it all goes, if there's no perfect legal vacuum, but in a perfect legal vacuum, meaning we don't have realities we have to deal with where it might change some of this, we would say, all right, let's bring in a forensic expert. I'll hire them, I'll engage them on my paper so that we can try to protect things on attorney-client privilege. And then they're going to dig in and start figuring out what happened. We're going to stop the bleeding. We're going to start digging in to understand the nature of what has happened, what data was impacted. That's a very important primary work stream. Another important primary work stream is we're going to have, as that information becomes available, we're going to be doing an analysis on the legal side to understand what does that mean? What jurisdictions are impacted? Where are these people? And so it's kind of a constant flow of information. There's an analysis going on this track. I think another important track that's going on in parallel is thinking about communication. So initially, we hope nobody knows anything about this. We haven't decided whether or not we have a breach. We haven't decided if we're going to go out and tell anybody about it. And I can tell you without fail, at least in the retail for-profit space, when there's an incident, I've never had a client say, I can't wait to notify people. You know, the whole idea is help me figure out if I have to notify. I'd really rather not if we don't have to. And sometimes that is the answer. You don't have to after we do the analysis. So that's an important concept to keep in mind. We have to first get our arms around it before we rush out and start talking about it. But from a communication standpoint, what's important is as soon as we can, as soon as we have the first bit of information, let's start preparing our messaging. We might not know very much initially, and so we just do base messaging. Here's what we know. Here's what we know. There's been an issue. We're looking into it. We've retained an investigator, and we're gonna look into this. That may be all we know, but the key to having to being able to be consistent in your messaging, to be controlled in your messaging, is to start as soon as possible with some kind of base messaging, and then as you learn things going through the process, you can amend that messaging. But everybody's working off that main base messaging. That's going to be so much better for you in the end than everybody kind of coming up with their own thing. CEO wants to talk to the press. The PR people want to talk to somebody. People internally are calling their business partners. Hey, I know you gave us some data. You're probably going to hear about it. We've got a problem. That creates an entire mess that just is harder to handle. So message discipline, starting with what we know and then expanding from there. Okay, I probably covered a couple of slides just telling you that, but that's all important stuff. We're addressing the technical and practical and legal concerns. Keep mentioning those separate buckets. They're all very important. It's important to marry those together so that we get the best outcome. So when we talk about coordinating the activities being key, and it's among different players in the organization, just think about, this is just a list here, an example. There are other people that may be important in this, this kind of analysis or consideration. That is, you got your CFO. You might have, typically a CEO wants to get out in front of it, wants to be in control of the situation and say, I got this, I'm going to go talk to the press, tell everybody to calm down, we got this. That's one person to keep in mind, and their motivations. Everybody wants to do what's right for the company, but people have different kind of ideas on how to manage that. And it's not every CEO. I don't mean to suggest that. I'm just saying I've seen this. Some CEOs might take that approach because they feel the responsibility of the organization. The CFO might be thinking about certain things related to exposure, and that's kind of what's got their mind spinning. You see these others there, customer service. I'd say your business relationship partners and that group, your IT group is involved, and they are going to have their own concerns and approaches to things. So this coordination of activity is very important, and that's what we get from bringing the core people together, saying, all right, look, we're going to do this in a coordinated way, and we're going to have a command center. I would like for that to be the legal department, if you have a legal department. If not, it's going to be somebody in technology, but hopefully with legal advice, where we can make sure there's a hub where all the information's coming in, and then information comes out from that hub, if that makes sense. If you visualize that, it means we're going to have that same information coming out, even though it's going in different directions. My business partners, my end users, maybe I need to talk to the press, whatever it's going to be. Okay, let me stick to my slides here. I did say message discipline, we've already done that. Moving quickly but calmly, that's kind of just practical advice. It is typically a chaotic situation, and there's some confusion on who should do what, and moving quickly is important, but staying calm is important. I had a client one time, and I thought it was a great idea. It seemed to work, but they said they wanted to have daily huddles with their internal executive team, or the people on the incident response team, just daily. Even if there was really no update, let's just have a daily call. And he said it's because, he goes, when you're talking to everybody, it seems to calm everybody down. So I don't know if he meant I'm putting them to sleep, or if he meant it really helps them stay calm. But he knew that was going to help us get a better outcome, not because it's me. It just happened to be somebody on the outside who can say, hey, look, everything's going to be all right. We're going to get through it. Yeah, it's going to be painful. We're going to get through it, and we're going to get a better outcome than we otherwise would have if you weren't doing what you're doing today in this activity, is how I would put it to them. So remembering also, some of you are going to have familiarity with the breach, some are not, so it's going to be a first-time experience. That's part of what creates the chaos and uncertainty. All right, when we shift now to the legal considerations in a breach, just double checking my time here. So everyone, this is kind of a default rule. It's a good thing to just keep in mind. Consider that, because I think regulators and plaintiffs' lawyers will say this to you if there's ever a problem, but think of it as an obligation to do a reasonable investigation. So you have to conduct a reasonable investigation. Well, there's no perfect definition of reasonable. It's what would a reasonably prudent person do under the circumstances is kind of how to think about it. That's not really clear. But you can tell that's kind of the thrust of that is, hey, look, you need to do what makes sense under the circumstances to figure out what happened so that you can understand who was impacted, so that we can do the things we're supposed to do under the law to help people avoid loss and hopefully harm to the organization as well. When you think about doing a reasonable investigation, the reason why I've highlighted that for you is because in my experience, sometimes the forensics people, they're really good at what they do, but they might start down a rabbit hole that they don't need to go down. And it's because, especially if a client that has a lot of money and they're willing to pay for whatever the forensic people need to do, the forensic people might get so excited about all these different potential rabbit holes. Well, yeah, but if we if we do that, if we scan everybody's computer in the entire organization, around the world, that's going to give us everything we could possibly need. Some things aren't necessary in order for us to complete a reasonable investigation. And I personally don't like to turn over. I don't want to turn over rocks we don't need to turn over. I want us to turn over the rocks that make sense to turn over, and let's see what's under there, and then we'll deal with it. I have seen forensic experts who are great at what they're doing, but they get, I'm going to say, off mission. They lose focus because the focus is about helping the client kind of determine what's wrong, what has happened, how can we fix it. Let's figure out who was impacted so we can figure out what our obligations are and comply with the law. But I don't have clients who are interested in trying to find out who did this, who are the bad guys. I want to know if it's somebody over in Eastern Europe doing this. I want to. That doesn't solve that would not solve my client's problem or address their concerns. Their concern is, how do I protect my business? How do I protect my people, my end users? That's what I'm focused on. Now, law enforcement might get excited about who was involved, and that could be helpful in the end for the greater good, but it won't surprise you to know that typically in a breach situation, it's more about the company versus kind of the greater good, at least in most situations. So conduct a reasonable investigation. Let's dig where we need to dig and make sense, and consider engaging your lawyer to oversee that process for attorney-client privilege. We could do an entire, there's a lot of, there's case law. This is a developing area of the law around attorney-client privilege protection. But I had a really good question from somebody at our first thing, I guess Monday night. They did like a speaker's thing for RVAsec, and I had a great question from somebody. Said, what is the point? They're used to doing the attorney-client privilege thing where the lawyer goes, okay, I'm going to retain you as the person coming in to do the forensics work. And they're fine with that because they're just going to do pretty much the same thing they were going to do anyway. They're just signing a different piece of paper. It's with the law firm. The whole point of that is to try as best we can. There are regulators and plaintiffs' lawyers who will try to pierce this attorney-client privilege or work product protection in a litigation setting. They're two different things, but they're similar in the sense that they're both protections for the organization. But think about the discussions that are going to take place. I'm going to give you just a quick example. CEO or chief technology officer hires a forensic person to come in, do the work, figure out what happened. In the process of figuring it out, there's all kinds of discussions about, hey, I need to understand more about how you guys do this. How do you do that? Why were you doing that? Oh, we don't do that because that costs too much money. And we'd rather put our money into, marketing. We got to drive business. We don't have the money for that particular security mechanism. And somebody else might say, well, I told somebody we should be dealing with this. This has been a problem for years. So this is all part of the discussion going on potentially with that forensic provider. And some of that's helpful to the forensic provider, some might not be. And then it helps them do their job and figure out what happened and what we need to do, where to look, and how to fix things. None of that's protected. So a year from now, when the plaintiff's lawyers start circling and the regulators start digging into this, assuming we had to go public with it, they start digging into it, all that stuff's fair game. It's like, did you bring somebody in? Oh yeah, I got ABC Company to come in here. Okay, well, in that case, I'd like to know who was involved at ABC Company, who was involved in those discussions on your side. Great, now I'd like to talk to them. I'd like to depose some of them and get some of that testimony. It would be much better for us if we can start from the position of, hey, look, all those discussions we had at that time, that was under attorney-client privilege to help my lawyer, this is you talking, to help my lawyer provide legal advice to me. So the lawyers need the help of the forensic people because we don't know how to do that. We learn a lot over time, but I can't dig in there and tell you about the ransomware or anything else about your incident the way a forensic person can. So I need that forensic person as a lawyer to help me provide legal advice to the client. So that's kind of the setting and how we turn it into a situation where we may be able to protect that information. And I say may because there are different things that can happen where you can lose the privilege or a court might say, no, you're just playing games. But generally, I can tell you, you're coming out of the gate in a better position to protect those discussions by starting the right way with attorney-client privilege. So look, it's not every situation that's going to happen. I realize that. Practically speaking, sometimes you're just moving really quickly. I get involved sometimes after it's, the train's already running down the tracks and the forensic people are already in there. We just deal with what we have and we keep moving. But in that perfect legal vacuum that doesn't exist, you would start by calling your lawyer, and the lawyer would go, oh yeah, let me get a forensic provider in here. I'll engage them, we'll come in and I'll oversee the work, we'll get it done for you, and then I can give you legal advice about how you comply with your legal obligations. Okay. You get the maintaining logs and IT data. That stuff's really important. Any kind of crumbs we can find and learn from. That's always important to us on the legal side and helping to figure out whether or not the client, thank you, has legal obligations. All right. Caution on written communications. Very important. Again, these are war stories, real stuff I've seen. But caution on written communications. When you have your team, even if you don't have a lawyer involved, it's very wise, if you can, to try to get everybody on the team to just discuss, have these discussions and communications orally if you can. I realize now with remote work, everybody's everywhere. You kind of have to do what makes sense under the circumstances. The reality is there will be written communications. But just be careful about what is put in writing. Help your team understand we need to be careful about this. It will inevitably, stuff gets taken out of context. Plaintiffs' lawyers love it because they can look at that email and go, yeah, well, you're telling me this, but look here, Johnny sent this email that says, I told these jokers that they should have fixed that last year. It's like, oh, that's awful. So we can't change the facts as lawyers, and I wouldn't want you to try to change the facts of what really happened, what really was said in some of these discussions. What we're trying to do is prevent it from being misused or used against you in a way that's just not, it's not helpful when we're dealing with this 6 months, a year from now when people are coming after you, regulators or plaintiffs' lawyers. We don't need to lay it out for them, really, is what I'm saying. You don't need to draw it out for them by being able to lay out and say, yeah, here's all the emails where we talked about all the problems. They can ask questions about that, but it's on them to figure out the right questions to ask, and then we'll respond truthfully. Unless it's attorney-client privilege. All right, so we talked about, I love that line. Remember, it could become Exhibit A. That's the way to think about it. Right before you push send on that email or that Slack or whatever it is you're doing, communicating, it's like, what's this going to look like when it goes up on the big screen in court? Is that how I'm going to want that to read? Just limit the information. Don't speculate about things. Just keep it factual if you have to do stuff in writing. I think that's more helpful later. Okay, another part of legal considerations. It's the individuals and regulators, just the different parties that have to be notified. It depends. That's such a lawyer thing to say, but it really depends on your situation. You may only have to notify individuals. You might have to notify individuals and regulators. You might have to notify law enforcement. You might have to notify credit reporting agencies, depending on how big the particular breach is. And I mentioned that there's an analysis of the incident, and the lawyers like this stuff. It's interesting. I'm sorry for my clients that it has to be done, but we have to look at each jurisdiction that's impacted, where the people are, and understand where they are, what data was impacted. All of that is going to be important to the analysis under the law in that particular jurisdiction. Some of them are very similar, but there are a number that are very different. And you have to look at each one to say, okay, did I trigger a notification obligation there? And that's to get the legal answer. Then you have the practical thing you have to answer, which is, if I only notify some of my people and not the others, is that going to create a bigger nightmare for me? Maybe I just notify everybody. These are some of the judgment calls you have to make, but we want to do the analysis to understand. In some cases, we do the analysis, and it turns out we thought this was a nightmare scenario, and we really don't have any notification obligations. You might still decide to, for whatever reason, but you won't be legally obligated to do it. So it's important analysis. Of all the things I'm going to tell you, this is one of the most important. That last bullet point. This comes up a lot. It came up recently in a situation I was dealing with. The general rule is this: if it's your data, you're responsible for all these obligations we're talking about. So what I mean by that is, you might give that data to a third-party thank you vendor. This guy's about to tell me to shut it and get off the stage. All right. You may have given your data to a third-party vendor that's performing a service for you. they're doing stuff to the data. They have a big data breach. Now all your data's out there. It is all they, under the typical legal scheme, their obligation is going to be to notify you. And that's it. To say, hey, got bad news. We had a big, massive data breach. All 10 million of your customers, that information is out there. That's their legal, and then to cooperate, give you some information. But that's it. They don't have to go out and notify everybody. It's still on you. So that becomes important when we start talking about, maybe that's what this one is. No, but we're going to get there. It's important when you think about what I just said, because there are things we can do in a contract to change some of that, shift that risk. So if I'm giving you data and you're handling it, perhaps in the contract we should talk about what happens if you have a data breach. I'm the one that's going to have the obligation to go out and notify. That's expensive. I'm going to give credit monitoring, identity theft, protection, services. I have to talk to the regulators. I want to put it in my contract. Consider negotiating something around that. Who's going to cover it? If it's your fault, maybe we should work it into the contract that you cover me and my expenses in dealing with all this, or you do it with my consent around, yeah, okay, I like your notice, yeah, you take care of it. You send it out. So very common for those to be negotiated things, but you see, that's one thing you're not required legally to do, but I'm telling you, it's in the legal realm, and it can be very helpful to you and your organization that you build that into your contracts. Man, we've already hit a number of these things. That's great. Yeah, coordinating the messaging, talked about that. We've already crushed this slide. All right. Keep the initial team small. Keep the initial team small and expand as needed. It's just human nature. Inevitably, the more people you have in your group initially to figure this out, the more likely it is information is going to leak and get out. Not because anybody's doing anything bad. It's just like somebody's talking on the phone, talking to a spouse, boyfriend, girlfriend, whatever. All of a sudden, information starts getting out. We want to keep this contained until we figure out what's happened. And let's add people as needed, but let's keep it small. Got to notify. Remember to notify your insurance carrier if you have it. If you don't have insurance, that's something else to think about. That's just a practical tip that will help you minimize the impact. You have an insurance company behind you that can help offset some of those losses and all of those expenses we were talking about on some of those earlier slides, those 2 slides of losses and expenses. Insurance can cover some of that stuff. Perhaps not all of it, but certainly some of that stuff. A mailing vendor, typically a call center, my experience has been call center and mailing vendor are combined into one vendor. It's one vendor that offers those services combined. They do a great job, and that's something to consider if you're dealing with a lot of notifications. It's a much easier process, and I think it gives you a better outcome. So I have it under practical considerations here for you. An after-action review, very important. After we're done, let's sit down and look at it and go, what did we do well? Now we've made it through. Everybody's okay. We're better because we went through it. Let's do an after-action review and figure out how we might do better next time. Hopefully there won't be one, but that's going to be an important thing for us to consider. Proactive measures, we're really hauling in on the end here. This might be the last slide. There might be one more after this. Proactive measures help ensure a better outcome. We've talked about complying with your legal obligations. I just want to make sure that's clear. There are obligations. Think about if you don't comply with those, then you have a breach. Then the regulator shows up and goes, well, how come you weren't doing that back here? That's a problem for us. So we want to make sure we're complying with our legal obligations and then complying with our notification obligations as a separate legal obligation. Regularly assessing risk, doing your testing. A lot of pen testing stuff I'm hearing from folks here. And I think all of those things are really important. Technical and practical things you can do. Requiring your vendors to be the ones who are going to touch that data. Require them to maintain security. In a number of cases, that's an obligation, depending on the legal scheme that applies to you. You need to be diligent about picking your vendors and kind of reviewing their situation. Shifting risk to vendors, we already talked about that. That's huge. Put it in your contracts. Talk about it. It depends on who has the leverage. You're not going to get Amazon to agree to take on all your exposure. But depending on the leverage, that's an important thing to at least have a conversation about with someone who's touching your data. And if you're touching someone else's data, understand that's where that's going to come in too. They're going to expect you to take care of them if you create the problem. Tabletops with an incident response plan. Incident response planning is so important. It helps everybody stay calm. I call it the game plan for game day. It's game day. We just pull it out, dust it off, and we're rocking and rolling. We know who to contact, how. What do you do when communications are down? I've got another way to contact you. Who's a backup? Things that are going to be important in helping you get the best outcome. We did it. Conclusion is an effective breach response. It's multi-party, multi-path, interdisciplinary, coordinated effort. You can see that through what we've talked about. And then planning reduces that chance of chaos and helps us ensure a better outcome. And that's it. I think we did it. 4 minutes to spare. Anybody have questions? Now we'll do back to it. Yeah, I think we have like a minute or two, maybe. He's got an STFU sign. That's beautiful. I was about to get that one. He kept popping signs up. I'm like, oh, here it comes. Yes, sir. A question over here.
Yeah, just curious on, in your experience, how long the investigation period typically lasts or maybe should last.
Yeah, great. That's a great thing to think about because it does impact, ultimately, you want it to be, I'll go back to that move quickly but calmly. And I've seen investigations run, a matter of I'd say a week when we're really hustling. People are working 24 hours and we're knocking it out. And I've seen investigations last a couple of months. I start to, I don't like it to last a long time because then it's more to explain. The optics are better. You think about it, a regulator, you have to be kind of skeptical, but a regulator might say, well, what the heck took you so long? Why? They weren't there, but they're looking into it and going, all this time people are being harmed, is what they would say. Being harmed, and you're just twiddling your thumbs. So sometimes it does require more time, but I would say faster is better, and I would say a couple of months is probably that outside of what I've seen. Yes, sir.
How have you seen the Virginia Data Protection Act kind of influence any of these?
Well, yeah, look, great. Talking about the Virginia Data Protection Act. So Virginia was one of the first states to adopt a comprehensive privacy law. And there are a number of exceptions to it, but I think it's a good thing for, I'll say, for consumers, for people whose information, I have clients who don't like it, but from a business standpoint, but certainly for individuals it's good and more protective of their information. The key thing I think to think about there is the distinction between security and privacy. And sometimes I find them getting lumped together. People say, oh yeah, okay, I got 2 minutes. Sometimes I find them being lumped together. I didn't get the STFU, it's coming. Sometimes they get lumped together. People say, oh yeah, we got to make sure we're careful about our privacy. Well, remember, they're separate things. Privacy is about what do I need to tell you about, and for what do I need your consent in order to take your data when I collect it and to do things with it. What can I do with your data lawfully based on our interactions? That's kind of the way to think about privacy. Security is the other side of the laws saying, certain laws saying, here's what you better do to secure that data and keep it, maintain the CIA, confidentiality, integrity, availability of information, and address that. But they are very important to look at together because they're both very important schemes. And some privacy schemes talk about data security. There's exposure for breach in some of those. All right, 1 minute. I think I can do it. What's one more question? Anybody? All right, that's it? All right. Thank y'all very, very much. I really appreciate it.